Okay, now let's look at the question 1A. So firstly, under company law, once a company is incorporated, it is treated as a separate legal person. So this principle was firmly established in the landmark case of Solomon versus Solomon and Co. Limited, 1897. In that case, the court decided that the company has its own identity separate from its shareholders and directors. This means the company can own property in its own name. It can sue and be sued, and its liability are not automatically the personal liability of the owners. Applying this to John's situation, if he and Maria set up JM Enterprise Sendirian Berhad, the shop would legally belong to the company, not to John or Maria personally. Ahmad would then have to deal with the company if he still wanted the shop. However, the law also recognizes situations where this separation may be abused. This is where the concept of lifting the corporate veils comes in. Normally, the veils protect the owners and keeps the company separate. But if a company is used for fraudulent or dishonest purpose or to evade existing obligations, courts may decide to ignore this separation. For example, in Guilford Motors Company versus Horn 1933, the court lifted the veil because the company was set up to avoid a contractual restriction. Similar in John and Lipman 1962, the veil has lifted when a company was used to escape from the land sale agreement. Therefore, in John's case, if JM Enterprise was formed purely as a tool to prevent Ahmad from buying the shop, the court could consider lifting the veil and treating the transaction as a sham. In summary, the principle of separate legal entities protect shareholders and directors, but the veil may be lifted when the company is used in bad faith or to avoid legitimate rights.
Assalamualaikum, my name is Nazir Hassan, and now let's look at the question B. Ahmad had an agreement with John to buy the shop, but instead of selling it to Ahmad, John transferred it to JM Enterprise, a company that he formed with his wife. The main issue here is whether Ahmad can still enforce his right and claim ownership despite the transfer. To answer this, we need to consider the Contract Act 1950, the Specific Relief Act 1950, and the doctrine of lifting the corporate veil, supported by both common law and Malaysian cases. Now let's move to the legal issues and the explanation. First, there was a valid contract under Section 10, Contract Act 1950. A contract requires offer, acceptance, consideration, and also intention. John offered and Ahmad accepted, so all elements were present. In Guting v. Lin 1831, the court stressed that certainty of term is essential. Here, the terms were clear, so the contract is valid. Second, John's sale to JM Enterprise amount to a breach under Section 40 Contract Act 1950. Refusal or failure to perform is a breach. By transferring the shop, John disabled himself from performing his promise. This is similar to Tan Swee Ho Co. Ltd v. Ali Hussein Bros in 1980, where non-performance was treated as breach. And thirdly, Ahmad can enforce the agreement. Land contracts are often enforced by specific performance under the Specific Relief Act 1950 because the damages are not adequate. Now I'm going to talk about the case and the conclusion. In Jones v. Lipman in 1962, the seller transferred land to a company to avoid the sale. The court treated the company as a sham and still ordered specific performance. Similarly, in Malaysia, Aspatra v. Bank Bumiputra 1988 confirmed that the veil can be lifted where a company is used for fraud or improper purposes. And lastly, to conclude, Ahmad's contract with John is valid and John's refusal amounts to breach, and the remedy of specific performance is appropriate. And based on both statute and case law, Ahmad has a strong likelihood of success, and the court will most likely grant him the ownership of the shop.
Assalamualaikum and hi. Now I will answer the question number 2A. Discuss with Pajura the validity of the contract. Now let me advise Pajura about the agreement you signed with Zuripin and whether it is valid or not. Under the Contract Act 1950, a contract must have free consent in order to be binding. If consent is obtained through coercion, fraud or misrepresentation, the contract is voidable at the option of the innocent party. In your case, Zuripin threatened you and also misrepresented ownership of the painting. Let us examine this issue step by step. First, the common law case in Derry v. Peake 1889, the court explained that fraud happens when a false representation is made knowingly, without belief in its truth, or recklessly. Zuripin falsely claimed ownership of the painting and tried to sell counterfeit works. His conduct clearly fits the definition of fraud given Derry v. Peake, and this support your right to challenge the agreement. Second, the statutory provision under the Contract Act 1950, Section 15 defines coercion as committing or threatening an unlawful act. Zuripin threat to spread false rumor about your artwork amount to coercion. Section 17 defines fraud as knowingly making false statement by deceit, by misrepresenting ownership and authenticity of the painting. Zuripin committed fraud. Section 19 provides that any agreement obtained by coercion or fraud is voidable at the option of the innocent party. In this case, you, Pajura, are the innocent party. We can also look at the Companies Act 2016, Section 213, which requires director to act honestly and in good faith. Although this case involves individuals, it shows that dishonesty and fraud in business dealing will not be protected by law. Third, the Malaysian case in Kesalmal v. Valiappa Cetia 1954. The court ruled that a contract signed under coercion is voidable. This supports your right to cancel the agreement since your consent was not free. In Tan Chi Chu v. Eastern Mining and Metals Company Limited 1964, the court held that false representation amount to fraud and made the contract voidable. This directly applies to the misrepresentation made to you by Zuripin. In conclusion, Pajura, the contract you signed with Zuripin is not valid. His threat amounted to coercion, and his false claim of ownership amounted to be fraud. Based on the common law case of Derry v. Peake, the statutory provision of the Contract Act 1950 and the Companies Act 2016 and the Malaysian case of Kesalman and Tan Chi Chu, you have the right to rescind the agreement. You are not bound to perform it, and the law is on your side. Thank you.
Hi, Assalamualaikum. So my name is Adi Farhan B. Azmi. So today I will present about question 2B, which asks whether Zuripin's threats and his false ownership affect the enforceability of the contract with Pajura. So we move to the legal issue. The legal issue is about whether the agreement is valid or not. We focus on two things. First, the effect of Zuripin's threats, and second, the issue of ownership and counterfeit paintings. Both come under the Contracts Act 1950. So we move to the effect of trades. Under Section 14 of the Act, consent must be free. Section 15 explains that if someone forces another person to sign by trades, it is coercion. Here, Zuripin threatened to spread false rumors if Pajura didn't sign. This clearly shows coercion. According to Section 19, a contract made under coercion is voidable at the choice of the victim. This means Pajura can either cancel the contract or continue it. The case of Barton v. Armstrong shows that threats make a contract voidable, and in Kasamal v. Valyappa Chetya, intimidation also made the contract invalid. So the threats make this contract unenforceable against Pajura. Next, for effect of ownership, Zulripin did not own the paintings and some were fake. This is fraud under Section 17 of the Act because he lied about ownership. So the legal rule is nemo that quod non habet, meaning no one can give what they do not own. Since he had no ownership, the contract cannot be enforced. In Tan Chie Chiu v. Eastern meaning, the court held that false claims make a contract voidable. Similarly, in Redgrave v. Hart, the innocent party can cancel if misled, if they could have checked the truth. So fraud here also makes the contract voidable. To conclude, both Zulripin's threats and his false ownership destroy the enforceability of the contract. The threats shows coercion and the fake ownership is fraud. Under the Contract Act 1950, this contract is voidable at Pajura's option. She may rescind it and also claim damages. In short, the contract cannot be enforced against her. Thank you.